Welcome to the press conference of the Committee on Members' Interests. We have the chair, Mr. Yu Siwing, here. So when you speak, please identify yourself and then raise your question. Standard. The complaint has been substantiated, but you are not going to take any disciplinary action because you say that it is not a deliberate concealment and there's no conflict of interest. Well, it was said that he thought that the shares had been transferred, but then between 2009 and 2012, he knew very well that he held the shares. He knew it, but he didn't declare. So how come that for the mistake committed for those 3 years, you're not going to penalize him? First of all, as to his explanation, we do not accept his explanation. When there is a failure to register, then it is a failure, and then it is a breach of the Rule of Procedures 823, and therefore, in accordance with the facts of the case, we have to check whether it has been deliberate and whether there has been a conflict of interest. On both counts, we do not believe that he has breached the relevant requirements. Moreover, for the third term as well as the fifth term of the electrical, 9 members committed a similar mistake. Other than one, where the nature is different, for the other 8 cases, they have been dealt with in the same way. That is, we do not recommend any sanction against Mr. Leung. Well, some might think that Mr. Leung, Andrew, is the president of the electrical, and so we have to take it very seriously. But then, please look at the title of the report carefully. It's about the Honorable Andrew Leung Kuen Yen. So for the CMI, when we work on the cases, we just treat each other in the capacity as a electrical member. We won't have a stricter requirement of him just because he's a president. So we have to consider whether it is an inadvertent mistake or whether it is a deliberate omission. Well, there were 2 complaints. One has been substantiated, the other hasn't. So you need to be clear about this point. For the first one, it hasn't been substantiated. For the second one, well, indeed, I believe that he didn't take it very seriously. He just thought that there had been a transfer of shares, and it turned out that there had not been a transfer. And in fact, we were not quite happy about it. So please refer to paragraph 34 of our report. Collectively, we felt that we were disappointed about that. But personally speaking, I think that he has not taken it seriously, and there was too rash for him to come up with that reply. For the CMI, we have been clear about the scope of our questions. It's not because he is the president, and so we want to make a fuss out of it. Internally speaking, his capacity as the president doesn't play any role at all. Good afternoon, Chair. Well, it has been said that failure to register is against the rule, and then you have to say whether it is deliberate and whether there has been conflict of interest. Well, he knew it. He didn't register. Why are you saying that this is not deliberate and no sanction would be issued against him? Just because there hasn't been anything done in the past for similar cases, and so from now on you won't be doing the same? Well, he has asked his secretary to make the arrangement. He didn't follow up on the work of the secretary. That is whether the secretary has really carried out his order, in other words, to register. Well, we accept his explanation. For the explanation, members of the CMI shared the same view. Therefore, since we accept his explanation, we apply the same rule when it came to the handling of similar cases committed by other members. Sorry, speaker is off mic. It depends on the case. We have to look at the element of the complaint, and then we have to look at the nature, whether it is deliberate and whether there has been any conflict of interest. Of course, we have to make reference to precedents. Otherwise, it won't be fair. If we single out certain members and try to handle their cases differently, then it won't be fair. From cable TV. Did you ever ask the secretary of Mr. Andrew Leung as to whether there had been an instruction from Mr. Leung in 2012 and whether it was true? We put the question in writing. Since he gave a reply formally, I don't think he would dare to give a false declaration. So I believe in that. Well, all the replies are in writing, in black and white. Commercial radio. Just now it has been said that the committee accepted his explanation, but I want to know on what basis you came to such a judgment. He did try to give up the shares. He did own the shares. Now you say that it wasn't a deliberate omission. What about the attitude of Mr. Andrew Leung in terms of cooperation? It seems that in his first reply, he didn't make it clear. He simply gave A. Leung. He didn't talk about who it was, and he talked about interest, but he didn't spell out the nature of the interest. Would you say that he wasn't very thorough in his reply given to you? Let's take a look at the first complaint. Well, I think the main point is about the nature of that company. So it's mainly to take care of the task given to the company by the Hong Kong company. So you may not accept everything in relation to that case. However, we have to judge whether the work done by that company is directly related to his capacity as a electrical member. If it is a very clear case that it contradicts or conflicts with his role as an electrical member, then we'll look at it more thoroughly. Now, he has got something in writing. Moreover, we've looked at the nature of that company, and in fact, owing to one reason or other, that company has stopped carrying out its business and has been disbanded. So I believe that the decision that we have made is an appropriate one. As to the other company, on the question of dealing with the shares, I agree with Ms. Mo. He has not done it in a thorough manner. On the first occasion, he admitted the ownership of the shares. Later on, he found out that he got it wrong. And so in his second reply, his explanation was that he got it wrong. So we believe that it was somehow misleading the committee. And that's why in our report, we have said that in relation to his way of handling it in the form of the second reply, we are disappointed. And then after he has been complained, for the first time that Andrew Leung gave us a reply, there was a gap of 7 weeks. 7 weeks. And then he still thought that since it was so set in the paper, then he thought that he owned the shares. So he admitted it. It's only on the second occasion that he gave a reply. He said that he was perplexed and he got it wrong. And he didn't tender any apology. So we have been quite polite when we say that we are disappointed. In fact, personally speaking, I would find it regrettable. Now 7 weeks. 7 weeks and still he didn't get it right. And it was only in the second reply letter that he was able to clarify it. So I would say that it is regrettable. As to whether he has been cooperative, well, we don't need to summon the person involved. So it's a matter of exchange of correspondence. So just like we are the plaintiff and you are the respondent, and if we have been summoning a respondent, then it would be like having a trial of a defendant. But then that's not the way, that's not the convention of the CMI. Unless it is absolutely necessary, we won't be calling them to appear before us. We resort to exchange of correspondence in writing. It depends on whether the explanation is reasonable. We still have the power to summon a member. It all depends on the explanation tendered. So we will look at these prevailing circumstances. And in some circumstances, the Secretariat would also verify the facts, and we also check the records on the internet. And we believe that the explanation is acceptable.
You may ask whether or not we are absolving him. I wouldn't use such a term. I would say that I would put it that he's able to get away. I think he's learned a lesson this time. Perhaps he's too busy. He owns too many companies and he has shares in different companies. I believe this was an inadvertent mistake on his part. He has only forgotten to register or declare the interest. In terms of the timing and the manner, the hazy and attitude that he replied to our inquiry is something that we would regret. But as for the rest, I will leave it to the judgment of the public. Well, it was mentioned that in the past there have been similar cases where the complaint was established, but there was no need for a penalty. Will the CMI maintain this stilled approach, which would result in members not taking seriously the declaration of interest or the registration of interest? I think the registration system for electrical members has been in place for a long time. As we all know, electrical is an organization which the public and the media is very concerned about. I believe members understand that they are public figures, and whatever they do, they need to be accountable to the public. So I think the present mechanism is still a suitable mechanism. Also, amongst us, we have 7 members from different political parties, and we also have, and they represent, the public. So in dealing with these issues, they need to be responsible to their constituents. So I think the registration system now is an honor system, and I think so far we should be able to maintain with such a system. For the last 3 terms, there have been similar cases which was purely because of the negligence, except for one case for which the member concerned was reprimanded. I think from the 3rd to the 5th term, a total of 9 cases have been addressed by the CMI involving members owning companies, but the case did not involve public funds or receiving interest, and the committee only reminded such members to be careful the next time, except for one case. I think for a particular case it involved, public funds. Someone suggested that if if the cases were treated so lightly, then members would simply, ignore the need to register. But I think you should understand that such news are actually accessible to everyone. It's not just the media. Even the public may find that if such the failure of declaration, is a serious matter, they can also complain to us. So the members are subject to public scrutiny. So I don't think members would take the registration of interest lightly.
English News, Francis. Just a very similar question similar questions with other reporters' question before. Under what basis did the committee judge that Mr. Leung's action was really just not deliberate? And because, as many of the reporters have pointed out before, he actually knows of such shareholding interest in a certain period of time. And also, some people may question that a elected president needs to hold a higher standard compared to all other lawmakers. Just can you explain to us why the committee made this decision?
I have to repeat that, look at this title of our report. This is our report of the committee on members' interests on a complaint against Honourable Andrew Leung Kwan Yeun. There's no suggestion that he's being investigated in his capacity as the president of LegCo, because we're all equal here, right, to start with. And our terms of reference makes it very clear that we need to look at two things. One, is it a deliberate act? And two, does that prove conflict of interest between what he's done, his lack of declaration, and his role as a legislator? And we're convinced that there's not much there. It's on the whole, a fairly minor case, I have to admit.
Thank you very much.